Not that bad.
Further hearing in the appeal, the Queen on the application of Nouazli and the Secretary of State for the Home Department.
Mr. Ward.
My Lord, thank you. During the course of argument yesterday, my Lord, Lord Carnworth, asked us to identify which grounds had been argued in the proceedings below. What you have before you is a landscape table prepared by my junior, Mr. Auburn, who in fact appeared below.
Oh, God.
And,
Probably the one asks a question and gets an answer, I think.
if it would assist, he's able to just briefly talk through it, or I'm content, of course, to leave it.
I mean,
Let's leave it for the moment,
leave it,
I think.
yep.
Yes.
Yeah, I see. Well, thank you.
I'm
Thank
told
you very
there's
much
one,
for that.
There's one refinement that Ms. Dubinsky has suggested this morning, so we'll, if necessary, we'll just send through a tracked changes corrected version, but it's on one minor point. Well, with that, I yesterday had dealt with the topic of discrimination, and I dealt with the statutory framework, and I was now going to head on to the topic of proportionality. And we start with a preliminary observation about what it is the Secretary of State is being asked to justify. Because this is an attack on a discretionary power, not a duty to detain. Yet the appellant's case is it's incapable of being used in any case in a way that is proportionate. It must be disapplied in each and every case, and it is invalid. And the reference for that is in the core volume at page 72, paragraph 27 of the appellant's case. And our contention, as already made yesterday, is that nothing comes close to demonstrating this. At the most, the appellant's claim is there might be some other cases where the power would be available in an EEA context, but not otherwise. Yet if the appellant is right, apparently the power can never be used.
So your point really amounts to this. The power can undoubtedly be used in circumstances where it's lawful. The fact that it might, in exceptional circumstances, be capable of being used in circumstances where in EU terms, and on the argument we've heard common law terms, it was unlawful, doesn't mean it's unlawful. It merely can't be used in those cases.
My Lord, exactly.
Yep, okay.
Exactly.
What
I
are we
want
actually being asked
Ali and
to do
Bibi
with
point.
Exactly.
I mean,
You're being asked to set it aside as invalid.
what are we being
We're wrong
asked
in
to
Ali and Bibi.
quash the
We're wrong
regulation?
in Ali and
Well, that's really a question for Mr. Saini.
Well, I
that
know,
appears
but
to
I'll
be
ask
the
him.
effect.
I mean, what do you understand?
That's how I understand the case. Because you will have seen it's been fought at a very high level of abstraction.
it has.
And the printed case makes virtually no reference to Mr. Nouazli's personal circumstances at all.
Do we know anything about his personal circumstances since his last conviction in early 2012?
No, the answer is
Do we know whether he's in prison now, for example?
He was here yesterday.
He was here
He was
yesterday.
He was here, yes.
Perhaps I can just make it absolutely clear. We do seek a quashing of it, and I think the court's understood our submission that the reason it has to be quashed on proportionality grounds is that it's not applied in the same circumstances for third country nationals.
Are we seeking damages as well?
Yes, if it follows that the regulation is to be quashed, then the instrument under which he was detained was not in existence, not validly in existence, and therefore he was unlawfully detained. Yes.
And what would be the quantum?
It would basically be damages for false imprisonment for that period of time
What,
to be
2
assessed.
months.
what sort of sum of money?
Well, I can't at the moment comment on that, my lord.
No idea at all.
Well,
500.
I think my junior may be more familiar than I am in terms
We're
of...
not being asked to deal with that.
Not at all.
There's
not
no
at all,
decision on
Not at all. That would have to be remitted as happened in...
It would help me personally at the end of the case if you could ask your junior to indicate a figure or bracket at least, which we might...
I can certainly do that, my lord.
Thank you very much.
I can certainly do that.
Well, with that, I was going to just take the court to two authorities which may assist, both with a point put to me by Lord Newberger yesterday, but also one of the grounds on which the regulation is said to be disproportionate, which is this. How is it that this can be said to be justified now, if not thought to be required in the year 2000? And there are two cases which, in my respectful submission, assist in answering that question. And the first is in the Authorities Bundle 7, under tab 76, which is a very early case, relatively early case of the European Court called Van Dyne. And the MS number...
Takes you back.
About as famous a case as...
Well, indeed.
When you were young.
The passage in question
Indeed, when I
has
was
been much repeated ever since. And we see it on...
About to be repeated again, right?
Yes, I'm afraid so. MS page 2652.
Thank you.
And this, of
What's
course,
the name of the case?
Van Dyne.
Oh, I see Van Daan, yes, I see that, yeah.
On the Home Office.
And as the court will recall, this is a case about someone who wanted to come and do secretarial services for the Church of Scientology. The question was whether she could be debarred on public security, public interest ground, public policy grounds. So it long predates the directive, but actually it deals with the same statutory test. And I just wanted to show the court a very much repeated passage in paragraph 18.
Yes.
Where it says, picking up in the fourth line, it should be emphasised that the concept of public policy in the context of the community, and where in particular it's used as a justification for derogating from fundamental principle of free movement of workers, must be interpreted strictly. So its scope cannot be determined unilaterally by each member state without subject to control by the institutions of the community. Nevertheless, the particular circumstances justifying recourse to the concept of public policy may vary from one country to another and from one period to another, and it is therefore necessary in this matter to allow the competent national authorities an area of discretion within the limits imposed by the treaty. Now, something quite similar was said by this court in the Lumsden case, which I'd like to just remind you of very briefly, and that's under in volume 6, under tab 72. This time at page 2557.
Yep.
And it's paragraphs 63 and 64. The less restrictive alternative test, in other words, the necessity test, is not, however, applied mechanically. In the first place, the court has made it clear the burden of proof placed on the member state to establish that a measure is necessary does not require it to exclude hypothetical alternatives. Then there's a quote from a judgment of the court.
I think you've
at the end
set this out in your case, haven't you?
We have,
Yeah.
my lord, yes. So I'll be as brief as I can. So there's a quote from the judgment of the court, and then the critical point is the analysis of this court was at 64. The court has accepted that where a relevant public interest is engaged in an area where EU law has not imposed complete harmonisation, the member state possesses discretion, or sometimes said a margin of appreciation, not only in choosing an appropriate measure, but also in deciding on the level of protection to be given to the public interest in question. So here, obviously, I made the submission yesterday. What happened, in essence, in both the EU and the non-EU regimes, is that the level of protection afforded was increased over time, which evidently reflected a change of policy concern. And then finally, on the approach to proportionality, I simply want to remind the court of something which is developed in length in our printed case, which is to say, in the context of decisions to detain prior to removal for immigration purposes, there is a long-established line of authority in Strasbourg that a less intensive form of proportionality test applies. And the famous dictum appears in the Chahal case, which I'll just give the court the citation for. It's Authorities Bundle 12, tab 141, page 4201, paragraph 112, where the Court of Human Rights said that detention need not be reasonably considered necessary, for example, to prevent a person committing an offence or fleeing. And we've developed this argument at some length in our printed case. Mr. Saini didn't deal with it. I don't propose to develop it any further now. It's simply another, if you like, contextual reason why, at the very least, we say there is scope for judgment here. Now, against that background, I want to turn to the substance of the case on proportionality. And in short, our substantive answer to the case on proportionality is the same as the answer I gave yesterday on discrimination. So I don't propose to repeat that, but rather to deal with the specific points raised in the appellant's case, particularly at paragraph 74. Although to some extent these have also been strongly prefigured now. The first one I absolutely prefigured yesterday, where it is argued that an equally dangerous third country national who is not the beneficiary of the Citizens Directive is not subject to detention in the same circumstances. And what I said yesterday is that is a wholly question-begging formulation, as the so-called equally dangerous third country national would, in essence, have had to arrive at a point where none of the relevant controls for third country nationals applied. And you'll recall I gave a list of criteria. And I don't know if it's helpful for me to just recapitulate that point.
Yeah.
But in very brief terms, I said that such a so-called equally dangerous third country national would have had to obtain leave to enter, despite the threshold test that applied, avoid having limited leave to enter curtailed with its power of detention that's so strongly analogous to Regulation 24.1, then have obtained indefinite leave to remain so that that power was no longer available, yet their conduct, while serious enough to be analogous to Regulation 24.1, should not be such as to attract automatic deportation with its attendant power of detention.
I see the relevance of all that if one's looking at the discrimination claim. I'm just wondering what the relevance is when looking at proportionality, because if the scheme is proportionate, the fact it may not be applied to others may indicate there's a defective scheme in relation to them.
Absolutely.
But so either it's proportionate or it's not. Whether who else it applies to can't, as it seems to me, affect proportionality. It has everything to do with discrimination.
My lord, I do accept that submission, and of course one of the things we said about
I think
discrimination...
it's a statement, not a submission.
Sorry, so forgive me, my lord. I do respectfully agree with my lord's observation, and you have seen that we have indeed suggested that levelling down, as it's sometimes referred to, is a possibility in this case in respect of proportionality. But I merely reiterate these points to meet my friend's case that there's some obvious comparator who is worse off. But on one view, his complaint could be construed as saying, well, there are not enough people detained under a comparable power, because what about these Americans who don't seem to be vulnerable to it? But I do respectfully agree with my lord's observation. The second point was, I really have just dealt with, there was no analogous power until June 2009. Why do you need the power for June 2009 for the first time? I dealt with that yesterday, and I've just reiterated. And then the third point that is made is that the power is unnecessary because the Secretary of State can conduct her deliberations as to whether to proceed with expulsion during a custodial term, where one is indeed imposed. Now, we explained in our printed case why there are, in fact, a range of circumstances in which it may be necessary to act urgently. So time may have been served on remand. So at the time of sentencing, there is no prison sentence to be served. There may be a very short prison sentence that is the immediate trigger for the Secretary of State's action. Or there may be a person who comes to the attention of the Secretary of State through intelligence, say, or some other route that isn't simply the serving of a prison sentence. But we do accept, again, of course, that use of this power in an individual case is subject to proportionality control. It's a second set of considerations. But we don't accept that it's just axiomatic that the power cannot be used in any case where there is, in fact, time to have acted sooner. Because we're dealing here with people who, by definition, there are reasonable grounds to suspect that they will be removed because they satisfy the high EU threshold. That means there is a strong public interest in ensuring that they do not abscond and do not pose a threat to the public. It's an entirely fact-sensitive question whether that can happen in a particular case, but I don't accept that simply because there might have been time for another means to deal with the situation, that makes it axiomatically disproportionate. Now, I want to also just...
What's to stop the Secretary of State taking months and months and months to decide whether or not to deport?
To deport? Well, I mean, if the person is not in detention, then what is the difficulty in terms of the legal principles we are talking about? But obviously, there's a supervening proportionality requirement that will apply to any action by the Secretary of State in this field. But, my Lord, our submission is simply... If there are...
I'm talking about the period before the decision made. Well, we're talking here, aren't we, about detaining somebody during the time it takes to make a decision whether or not to deport.
So
I follow you have to satisfy that the test you've just referred to. But one would have thought, therefore, it was a pretty short time.
Yes.
unless there were some particular factual circumstances.
my
What's
lord-
to stop endless administrative delay while it's okay because we got him inside all's well?
Well, the answer is that any such delay is subject to the control of the courts. If the person is detained, then Hardial Singh applies. So, and that's obviously what I'm going to come on to in the next head. But if there is a question on the facts of a particular case about whether the Secretary of State has used the power properly, the power is subject to judicial review, it's subject to proportionality. But none of those possibilities can begin to support this very wide-ranging relief this court is being asked for.
Is the person in question required to be given an opportunity to make representations before a decision is taken?
May I just take instructions on that, my lord? I'm told that there would be representations. There would be an opportunity for representations by the detainee. But of course, again, if there's procedural unfairness involved, then that would be a potential issue in public law. So I can't point to anything very concrete. One thing I will show the court later is the guidance which now exists about how this power is used, because it's relevant to the Hardial Singh ground of challenge. But may I just also...
New guidance.
Just new guidance. So it didn't apply in this case, but because we're now also trying to assist the court with the position as it is today, I will show the court that in due course. But one thing I was just going to say, really for the court to note, is that you've heard no arguments at all, either orally or indeed in writing, about what actually happened in this case and the way the power was exercised. And the truth is that the facts were pretty messy, bluntly. And when you consider the statement of facts and issues, you will see that. But very importantly, those
The
facts...
facts were messy. I mean, the Secretary of State in a hopeless muddle as to what they were doing at any given moment.
My lord, your formulation, not mine. But there was a muddle. That's the reality. But the crucial reason you haven't heard nothing about this in argument is that there was an attempt in the Court of Appeal to introduce argument about those issues, and the Court of Appeal declined permission at that stage, which is why you haven't heard Mr. Saini
This is because the point wasn't taken earlier.
Yes. And just for the court's note...
So we're the only ones who hear points that weren't taken earlier. The Court of Appeal wouldn't have anything to do with it.
My lord, that seems to be the case. But in the Court of Appeal's judgment, it's in the core volume at page 242, and you can see it set out at paragraphs 19 to 22.
Thank you.
Well, I'm right.
That's the wrong reference. It's 21 to 23.
We're not faced with any argument that this decision was disproportionate, irrational, Wednesday unreasonable on the facts of this case. As I understand it, we're simply
that's my
concerned with
understanding. The claim is put more ambitiously at this high level of generality.
That's because they failed to take the point in time before the judge.
In essence. The final point I wanted to just touch on under the head of proportionality is the argument made in the printed case. I'm not sure it was made orally yesterday, that the appellant argues the measure is, because it's discriminatory, it's also disproportionate, I'm sorry. And of course, you'll anticipate our answer is, we've already said why it's not discriminatory, so repackaging this as a proportionality challenge simply cannot help. With that, I was going to leave proportionality and come on to the topic of fixed time limits and Hardial Singh.
Just before you do that,
My lord.
I was looking at the statement of facts and issues, and I see that indeed the first period of detention was triggered by a cascade of letters from the department, one of which invited representations within 20 days, working days, why he shouldn't be deported, and the second, following hard on the heels of the first, made the decision to deport. Now, I raise the matter not to highlight the muddle in the department, but simply for this reason. Absent a power in appropriate circumstances to detain pending a decision on deportation, is there a concern that for some people a letter inviting representations in 20 days would be an invitation to do a runner?
Well, my lord, that evidently could be the case, evidently.
But all that's fact sensitive.
It's all fact sensitive, exactly.
But if we're looking at whether it is proportionate to have the power,
Indeed.
it might be thought not a very difficult scenario to imagine.
Well, my lord, I absolutely accept that. Unless the court has further questions on that topic, I was going to turn to fixed time limits for detention. And the argument is that the very long-established Hardiel-Singh approach is no longer sufficient. And it's said to be insufficient on 3 grounds. Firstly, common law. So that is inescapably as a request that this court departs from the Hardiel-Singh jurisprudence. As to EU law, the reality is the appellant has cited reams of cases on legal certainty in various contexts, but none at all which deal with the specific question of what degree of rigidity is required for the purpose of duration of immigration detention. And then thirdly, there is Strasbourg case law, which is undoubtedly on point, but does not support the proposition which they seek to derive from it. But I thought it might be of just of assistance to remind the courts that there is no claim here under the Human Rights Act. So there's much discussion of Strasbourg case law, but only insofar as it informs either European Union law, or, of course, as Mr. Saini says, one can see the same requirements implicitly in the common law. But our submission is that when one focuses on the Strasbourg case law, it does not establish that fixed time limits are a mandatory legal requirement in every case. Instead, what it shows is that Hardiel-Singh itself is provides a sufficient degree of foreseeability to ensure that detention is not arbitrary. The cases which seem to show a concern about fixed time limits are ones in which there is no proper legal structure for regulating detention, or at least no enforceable rules about its duration. Before turning to that case law, though, I want to go back to a case Mr. Saini showed you, an English case, where, in my respectful submission, he misrepresented the Secretary of State's position. And that's in Authorities Bundle 6,
Yes.
under tab 74.
Thank you.
It's the case of Fardos.
Yes.
And you were shown yesterday, page
We looked at
26...
pages, the paragraph 35 and 36 on
That's right, my lord.
2621, yeah.
Thank you. And this is from the judgment of Lord Thomas.
Yes.
But what was said by Mr. Saini is that it was a sort of complaint by the Secretary of State that Hardiel-Singh was too uncertain. But that's not right. And we see the submissions of the Secretary of State at paragraphs 35 and 6. And if we read paragraph 36, the complaint was quite a different one. Secondly, the Secretary of State submits, the judge had failed to make an objective assessment of the facts as they appeared to those acting for the Secretary of State at the time, but had applied his own subjective views with the benefit of hindsight. This was inconsistent with the rule of law, as the Secretary of State had to be able to determine the lawfulness of detention on the facts as they appeared at the time the decision was made. So that's an entirely different point to that which Mr. Saini suggested could be derived.
Understand.
And it also, in fact, helps to underline a point that when Mr. Saini complains that Hardiel-Singh is all ex post facto, that's not right, because the Secretary of State is bound by Hardiel-Singh. He has to apply Hardiel-Singh in the first instance. And before we close this authority, I just also wanted to draw attention to paragraph 39, where, indeed, between 37 and 41, Lord Thomas talks about, essentially rejects the argument that you can derive a tariff from Hardiel-Singh, and adverts at paragraph 39 to 2 cases where the courts had said fixed time limits might actually be undesirable. So in other words, there's a policy concern going the other way. And it says that Lord Justice Macfarlane had observed that fixing a temporal yardstick might cause the courts to accept periods of detention that could not be justified on the facts. and that in a case NAB, Mr. Justice Irwin had said a tariff could be repugnant and wrong. And the reason in the underlying judgment is he was concerned that people subject to tariff might essentially game it and try and delay until the tariff expired. So I simply point out that there are these policy considerations the other way, if you like. So it's not an...
What's meant by a tariff?
Well, I don't wish to put a gloss on his lordship's words. Tariff, some sort of fixed period of the kind Mr. Saini is suggesting. In other words, the concern is if you have a tariff and you say, well, if I can delay my detention for 2 years by generally being obstructive, at that point I know I'll get out. That's the kind of consideration I think that was an issue in that case. Now, with that, if I may, I'd like to turn to the Strasbourg approach. And I want to start with a proposition of trite law, for which I will supply a reference, but perhaps to save time, not take the court to. The starting point is that Article 5 itself contains a requirement that any interference must be prescribed by law.
Yes.
And that one can see in Authorities Bundle 1 under tab 21 at page 807.
Yep.
Well,
Okay. Yep.
now, of course, that requirement of prescribed by law appears in many articles of the Convention.
Yes.
And it has been interpreted as requiring protection from arbitrary interference,
Yes.
including accessibility, foreseeability, and compliance with domestic law. And if an authority is needed for that, it can be found in the case of Gillen,
Yes.
which is in Authorities Bundle 3, tab 42, page 1468 at paragraph 32.
Again, I think we...
I imagine
Thank you
that's
for the reference.
familiar territory.
Yeah.
So the proposition one derives from this is that foreseeability is part of the requirement of lawfulness and part of the requirement of non-arbitrariness. And our core submission is that the rule in Hardy or Singh, which is also the rule in Chahal, is itself a manifestation of this rule. In other words, the requirement that detention should be limited to a reasonable time is a manifestation of this rule that detention must be prescribed by law. And to make that, I think, obvious point good, I would like to show you the case of Sardi, which is in Authorities Bundle 12 under tab 146. And this was an unsuccessful attempt to persuade Strasbourg to, I think, actually, I say it was unsuccessful, I'm not actually sure. Was it unsuccessful?
146.
146, and the passage we want is at page 4382. Sardi. No, there was a violation. It wasn't unsuccessful, it was successful. Never mind. So I said it was unsuccessful, but actually it was successful.
Right.
Thankfully, nothing turns on it. So I wanted to go to Sardi at page 4382. And this is a Grand Chamber case from 2008, where the Strasbourg court revisited and restated the famous principles in Chahal. And I'd like to pick it up, please, at paragraph 67, where it says, it is well established in the court's case law, under the subparagraphs of 5.1, that any deprivation of liberty must, in addition to falling within one of the exceptions, be lawful. And where the lawfulness of detention is in issue, including the question whether a procedure prescribed by law has been followed, the Convention essentially refers to national rules and lays down the obligation to conform to substantive and procedural rules of national law. Compliance with national law is not sufficient. Deprivation of liberty should be in keeping with the purpose of protecting the individual from arbitrariness. It is a fundamental principle that no detention which is arbitrary can be compatible with Article 5.1, and the notion of arbitrariness extends beyond lack of conformity with national law. So a deprivation of liberty may be lawful in terms of domestic law and still arbitrary. So that's really the court saying pretty much what I said a few moments ago. And then, very importantly, at paragraph 72, this is where the court discusses what was said in Chahal.
Yep.
Where a person has been detained under Article 5.1f, which is what we are concerned with, the Grand Chamber, interpreting the second limb of that paragraph, held as long as the person was being detained with a view to deportation, that is, as long as action was being taken with a view to deportation, There was no requirement detention be reasonably considered necessary, for example, to prevent the person committing an offence or fleeing. I referred to that earlier, but it's the next bit that's important now. The Grand Chamber further held in Chahal the principle of proportionality applied to detention under Article 5.1 only to the extent the detention could not continue for an unreasonable length of time. And then at 73, with regard to the foregoing, the court considers the principle detention should not be arbitrary, must apply. So not just proportionate, but arbitrary, in the same way as in other limbs. And then at 74, this is really the part I wanted to focus on, to avoid being branded as arbitrary, such detention must be in good faith, closely connected with the purpose, etc. And then underneath the quote, the length of detention should not exceed that reasonably required for the purpose pursued. So we see there in unambiguous terms, the Grand Chamber saying that the requirement of reasonable duration is itself a facet of the requirement of non-arbitrariness.
Yeah, there's findings on a different.
Okay. Thank you. So that's why we say that Hardiel Singh, which is the same test for this purpose, is simply an articulation and application of the principles of non-arbitrariness and legality in the context of detention. That is enough to secure the quality of law. Now, against me, Mr. Saini says things have moved on, and there is now a mandatory requirement of fixed time limits in Australian case law. And they cited a lot of cases for this. As my Lord Toulson observed yesterday, we responded in our printed case. But what I would like to do is just show you why we don't agree with the analysis of the two cases Mr. Saini took you to in oral argument. The first of which was Mathloom, and that is in bundle 14 under tab 165. And here we have the unofficial translation towards the back of the clip. And I wanted to take the court, please, to page 4874. And this is a complaint about duration and legality of detention in Greece. The facts don't matter at all. But what does matter is to see what the Greek provisions were that were actually an issue.
Yep.
And we see the relevant provision at the bottom of page 4874 in paragraph 30. And it's the provision of the Greek Criminal Code, Article 74, subparagraph 1, the court can order expulsion of a foreigner in certain circumstances. Article 74.4, the foreigner remains detained in special areas of prisons or detention facilities until his expulsion takes place. So nothing at all there, anywhere, about time limits. And then a couple of pages on, however, there is another paragraph which is important for the judgment, paragraph 35 on page 4877, where the court notes that an opinion has been given by a prosecutor of the Supreme Court, the prosecutor of the Supreme Court, in fairness, where you will see that it says in the last 4 lines that for the purpose of deportation, the short-term detention of aliens for the purpose of deportation, which did not exceed the reasonable period of 1 month, was necessary for execution of expulsion in accordance with the applicable legal provisions. That's what it says. And the question was there sufficient control of the period of detention under these Greek provisions? And to find the answer, we can turn on in the judgment to page 4884. And what the court says in a nutshell is, none of this is good enough. This doesn't amount to any kind of control over time, which it plainly doesn't. At paragraph 31, the court, I'm on page 4884.
Yep.
At paragraph 31, the court notes Article 74 of the Greek Criminal Code does not provide for a maximum limit of detention, beyond which, if expulsion is not carried out, it is assumed to be impossible. The court observes that in its opinion, the prosecutor of the Supreme Court noted detention for the purposes of a judicial order should not exceed a reasonable period of 1 month when necessary. In this regard, the court recalls it has already held the opinion of a public prosecutor is not a law, of sufficient quality within the meaning of its case law. And then at paragraph 33, it says, in the light of the above, the court concludes the relevant provisions of domestic law on detention do not set the maximum duration of detention and do not meet the requirement of foreseeability. In other words, in Greek law, there was no maximum limit of detention at all, or indeed any limit of detention. And by contrast, here in the United Kingdom, we have Hardy or Singh requirements, which do indeed set a maximum, albeit not by reference to a numerical tariff of the kind that Mr. Saini would like to see. And indeed, one can draw a very powerful distinction in the same authorities bundle, please, to a case where around the same time, a different chamber of the court considered Hardy or Singh. And this is a case called Tabassum under tab 164 in the same volume.
Thank you. Yep.
It's relevant, isn't it, to see in the Mathloom case at paragraph 61 that they rely on Sadi.
Oh yes, thank you, my lord. Thank you for pointing that out.
Authority, and which is also relied on in the case you're coming to now.
Yes, absolutely. And indeed, I think in all of Mr. Saini's cases, I hesitate to say it all, but I think that Sadi or Shahar was referred to in all of them.
But I mean, that is the leading Grand Chamber authority.
Well, without a shadow of a doubt. So it's quite contentious to suggest it's somehow wrong or overtaken. So if I may just show you briefly Tabassum, because this is the United Kingdom case, where we see at paragraph 6, please, in fact, we can see it best on page 4841, where you see, well, there was basically a complaint about a period of 2 years of detention. Picking up at page 4840, the basic issue was the onus was on the applicant to prove his claimed British citizenship, and the judge found that on the evidence before him, having regard to his dishonesty and use of false identities in the past, he had not done so. And then the complaint was a 2-year period of immigration detention too long? But we see at the top of page 3, the judge was satisfied, sorry, page 3 of the judgment, which is 4841 of the MS number. The judge was satisfied the Secretary of State was genuinely using the power to detain for the purposes of effecting the applicant's deportation. While the 2-year period of detention was long, it was not unreasonable. Hardy or Singh, obviously. And then at paragraph 10, lower down the page, the Strasbourg Court notes it notes that this court in Lumber had reaffirmed Hardy or Singh. We see that in paragraph 10.
Yep.
And then, in the analysis of the Strasbourg Court, if we pick up at paragraph 16, we see the Sadi approach is recited. And then at paragraph 17, the Strasbourg Court says the court observes the lawfulness of the applicant's detention was considered and confirmed by the High Court, which found the length of his detention was not unreasonable in all the circumstances. In other words, it's acknowledging that Hardy or Singh was applied. And then at paragraph 19, finally, as regards the length of detention, the court notes the High Court's findings that as of July 2011, this had not exceeded what was reasonable. And then a court accordingly concluded at paragraph 23, the court finds, having regard to the fact domestic authorities employed due diligence in attempting to secure the applicant's deportation throughout the entire period for which he was detained, his detention did not exceed what was reasonable in all the circumstances and was not arbitrary. And then you will see in paragraph 24, not just they rejected the complaint, but this was actually admissibility. It follows the applicant's complaint is manifestly ill-founded. So not arguable but wrong, but manifestly ill-founded. So on the face of it, therefore, what we have is a very strong reaffirmation that the Hardy or Singh principles are sufficient. Now, there was one other case of his many that Mr. Saini actually took you to, and I want to deal with that one as well. It's in a different authorities bundle. It's in bundle 13 under tab 150. And this was Abdul Khani. And the MS number we want is 4542.
Yep. Been here before, yeah.
And what we see...
Sorry, what tab number?
1542. and MS page 4542.
Well, we looked at this yesterday.
We looked at it yesterday, but Mr. Saini did not, in my respectful submission, draw the right conclusion from it. And we see at paragraph 131 what the complaint was. The present case, the applicants alleged they were not detained with a view to deportation and that in any case their detention did not have any legal basis in domestic law. And then at 132, the court notes that at the outset, the applicant's detention in the Haskoy police headquarters should be regarded as a deprivation of liberty. And then at the end of 132, in this connection, the court must ascertain whether the applicant's detention actually had a legal basis in domestic law. That was the issue. And the court observes the legal provisions referred to above by the respondent government provide that foreigners who do not have valid travel documents and who cannot be deported are obliged to reside at places designated by the ministry. These provisions do not refer to deprivation of liberty in the context of deportation proceedings. And then at 134, the same considerations are also applicable to the applicant's detention from 30th of June 2008 onwards. The government has failed to submit any argument or document indicating the applicant's detention to date has a strictly defined statutory basis in domestic law. That's the crucial proposition. And then in 135, in sum, in the absence of clear legal provisions establishing the procedure for ordering and extending detention with a view to deportation and setting time limits, the deprivation of liberty was not subscribed by adequate safeguards. So it's a total failure of legislative regime case. Of course, they mention time limits as part of that, but as I've already submitted, we do have a time limit in the United Kingdom. It's just hardy or sing rather than fixed by reference to a tariff. Exactly, my lord. Now, yesterday, Lord Carnworth asked me whether this issue had been considered in the domestic courts. And what I said is we had found 2 cases of potential assistance, which, for your note, are in our printed case in the core volume at MS 183, footnote 111. And I think, as there is time, I'll just show you briefly one of them. And it's in bundle 5 under tab 58. And it's a first instance decision of Mr. Justice Walker.
What page was that again?
It's tab 58. And
Yes.
I'm sorry, I'm looking for the MS page number. I'm
Don't
so
worry,
sorry.
I'll find it.
1984.
Yeah, I've got tab 58. Which paragraph number is it in the judgment?
Sorry. It's MS 2009 and it's paragraph 64.
Thank you. Yeah. Thank you.
And what we see is an argument was being advanced on the basis of Mafloon. And Mr. MacDonald, Queen's Counsel, who was acting for the appellant, commented it was consistent with established case law on the need for precision and foreseeability to require national authorities to set out a maximum period for administrative detention. That's very much Mr. Saini's argument before this court. If Mafloon had indeed required that domestic law set a maximum duration of such detention, then the law concerning false imprisonment as currently understood, which involves no such requirement, would fail to comply with Article 5. In my view, the decision in Mafloon does not go that far. The court merely noted the absence of maximum duration in Greek law. It did not say that Article 5 required such a maximum duration be specified by law. I do not detect any respect in which, as regards the present case, there is scope for saying Article 5 would add anything. So that's an answer to my Lord's question of yesterday.
And that's where, I mean, Mr. MacDonald is not noted for abandoning points which he thinks would be worth a run in a higher court.
Well, as far as I know, it didn't go further. This was done on the basis, frankly, of a word search of Mafloon for cases that look potentially of assistance.
Thank you.
So I can't say with confidence. So that's the position under the Convention. Does EU law somehow help? Oh, sorry, there is one other thing to say under the Convention, my mistake. Mr. Saini has pointed to 2 cases where this issue has been communicated to the United Kingdom by the Strasbourg Court. We, of course, don't know what the outcome will be. And indeed, when I checked on the Strasbourg Court's website, it didn't even appear that those cases had yet been held to be admissible. But the correct analysis at present, though, is there is no such general requirement in the law, And the case law I've showed this court establishes that at present, the Hardy or Singh requirements are plainly sufficient. Now,
if there's an argument about whether or not the time, or what was a reasonable time in a particular case, is that essentially a matter for the Secretary of State to decide, or is it a matter that the court decides for itself?
well, the Secretary of State has to comply with the Hardy or Singh principles. So it's not merely a second-order matter of review, but then when the matter comes before the court, my understanding is the court itself will decide if time is reasonable.
Yeah. And if it has been unreasonable, then the detention will have been unlawful and damages will be awarded.
From a particular date.
Yeah.
So the logic of that may be that for the last 6 months, say, detention has been unlawful.
Do you want to say anything about the principle, whether time limits ought to be made fixed, and what would be potential drawbacks in doing so?
Well, my Lord, what I would say is, well, firstly, I'm going to come on to some guidance the Secretary of State has propagated in this area, which does involve time limits. So I'm not about to make the submission that such time limits would be unlawful, even though they're only in guidance. But evidently there are policy considerations against them. And in the field of immigration, where, as was observed in argument yesterday, the matters may be completely out of control of this state as to why it may not be possible to remove someone within a particular time. So it's obvious that there would be situations where a highly fact-sensitive approach, rather than some sort of fixed time limit, ought to be applied. In this case, there is guidance now, but guidance, of course, as I accept, is not strictly binding, but I'm going to come on to that in a minute. So I do respectfully accept that there are significant policy considerations in favour of a flexible approach rather than a hard stop of the kind that Mr. Saini wants to argue for. Now, part of Mr. Saini's response to this has been to say, well, there's enough uncertainty about this law that this could be referred to the European Court of Justice, not the Strasbourg Court, of course, in respect of which there is no mechanism of reference. But there's a complete lack of reality in that submission because the Luxembourg case law doesn't engage with this issue at all. And in all of the authorities that have been produced on EU law in this area, there are none which deal with duration of detention prior to removal. And indeed, most of them are about things that are completely unrelated, such as...
That's because the point hasn't arisen, has it?
Well, it hasn't been considered in Luxembourg, and I fully accept that if Luxembourg were ever to consider it, it would look very closely at the Strasbourg case law. But the idea of referring this to Luxembourg so they can decide this point, in my respectful submission, just lacks reality. Now, Mr. Saini also relied on the requirements...
Why does it lack reality? Because we haven't the faintest idea what they might say?
No, my Lord, because
it's therefore not act clear.
Luxembourg court would say, well, if the argument is the Strasbourg court is thinking about this, the Luxembourg court would be very reluctant in my submission to take the lead and say, well, we've never dealt with these issues before at all, but nevertheless, we will decide now. Because, of course, in this area, in these kind of fundamental rights areas, the Luxembourg court generally does follow the approach of Strasbourg. I don't say always. There are some famous examples where it's gone its own way. But in my submission, it just isn't a serious proposition that this court should refer this question so that the Luxembourg court can decide what to do with it. The truth is the law is sufficiently clear as it stands, whether or not it might change in the future. Now, I was going to just mention the return directive, which Mr. Saini relied on. And you'll recall that is a directive which does not apply to EU nationals. It does not apply to EU nationals. Sorry, I was distracted there for a moment. The return directive does not apply in the United Kingdom. That's what I was trying to say. And it contains time limits for detention. But what we do say is there's no basis for this court to take those legislative requirements and somehow apply them through some common law mechanism or even court-based law mechanism more generally outside the scope of the return directive, and in particular, it must be said, in the United Kingdom, which is not bound by it. Our submission is, if the appellants can't establish their point by reference to the convention case law, they cannot establish it at all. The final thing I was going to say on this topic is about the guidance, which was promulgated after the facts in this case. It is, in fact, in a bundle. In fact, the appellants referred to it in their case. Now, just to remind the court of its own case law, it's well established that a decision maker must follow published policy unless there are good reasons to depart from it. And that's Lumber and Mighty, and the bundle reference, in fact, is in the bundles. It's tab A4, Authorities Bundle 4, tab 53, page 1713 at paragraph 26. So the guidance is not binding in the sense of statute law, but nor could it be described as a policy with no legal force at all, rather like an opinion of a Greek public prosecutor. If it's of assistance, I can show you the policy now, but it does indeed contain some actual time limits, as well as a substantive statement to the effect of the Chahal test. And that is in bundle A14 under tab 168. And if I could ask you to pick it up at page 4990, which is page 9 of the guidance.
Yep,
And the third paragraph in the central box of the page
yep.
says, although there is no official time limit in the regulations regarding maximum period of detention, the use of the power must be reasonable and respect the rights of the detainee under the European Convention. In practice, you must not detain a person under Regulation 24.1 for longer than is reasonably necessary for immigration officers to gather evidence in support of removal. So that's the Chahal test. And then over the page, there is actually a time limit.
Yes, I see.
In criminal cases, the maximum acceptable period of detention is 15 days. By the end of 15 days, a decision on whether deportation is to be pursued should have been made. If exceptionally the investigation is not concluded after 15 days, you can apply a further period of 15 days. However, detention under Regulation 24 must not last longer than 30 calendar days in total. It's only guidance. I don't wish to overstate its significance.
In this case, it lasted 2 months and then was followed by bail. So
Yes, indeed. And of course, this guidance simply wasn't in existence at the
Your
time.
curiosity, if he's being given 20 working days to respond, but the maximum period of detention is only 15 calendar days, how does it work?
Well, that wouldn't work, my lord, I entirely accept. And the 20-day letter that you saw was part of a model. So I accept that simply doesn't add up.
Right,
I can't make sense of that for you.
right.
Can I move on now? May I move on now to the final topic of the final head of challenge, which is about transposition of the directive. And the essential complaint is that Regulation 24.1 permits detention without Articles 27 and 28 having to be actually satisfied. And that's because it's sufficient if there are reasonable grounds to think that removal will occur. And the technical reason for this, if you like, in the technicalities, it said this problem arises because a decision to detain is not defined as an EEA decision under the regulations. So that's the issue. And I want to take it in 2 stages. Firstly, to show why there is a reference back to the requirements of Article 27 and 28. And then secondly, why the appellant's construction of the directive is simply unworkable. So it's firstly with the question of reference back. In a case of this kind, there is a reference back to the requirements of Article 27 and 28 built into the regulations. May I ask you to pick up Authorities Bundle 1 so we can see the legislation? And it's under tab 10 in its current form. And I'm going to show you the historic form as well in a moment. And if we could go to MS number 7, sorry, I have the wrong reference here. I said tab 10, that's wrong, it's tab 9. I'm so sorry, and it's page 701.
Yes.
It's familiar territory, but I just want to show the connections. 24.1. If there are reasonable grounds for suspecting that a person is someone who may be removed from the United Kingdom under Regulation 19.3b, that person may be detained. So let's now look at Regulation 19.3b, which is at page 690. And Regulation 9.3b provides that an EEA national may be removed if the Secretary of State has decided that the person's removal is justified on grounds of public policy, public security or public health in accordance with Regulation 21. Then Regulation 21 is on page 695, and one can see just at a glance that what it does is set out the requirements of Articles 27 and 28 of the directive. Now, one thing Mr. Saini says is, well, it doesn't actually distinguish between Articles 27 and 28. But in the context we are concerned with, that does not matter, because we are concerned with the decision to remove. And Articles 27 and 28 are both relevant. So that's why I say there is a reference back in Article 24.1 to essentially the directive requirements. Now, before I go to the next step of my argument, I need to address the historic position as the law applied to Mr. Nouazli. Because this version of Regulations 24 and 19 only came into effect a few weeks after his detention. So in April, on the 3rd of April 2012, an earlier version was in force. And the easiest place to see that is actually the appendix to the appellant's note on the law, which is, so I don't know where it lives in terms of bundles, but it's at page 16 of that note on the statutory framework.
Right. Page 16.
Page 16, which is part of its Annex 2, where we can see how the power applied at the time
Sorry,
of
his annex to...
well, page 16, within
What is
there,
note to?
the appellant's note on, I'll just give you the proper title of it.
There's something called his note to.
That's it.
Yeah, note 2, concerning statutory and functional contracts. And it's page 16, where we agree they have correctly set out the iterations of this legislation.
And it doesn't limit it to B.
It doesn't limit it to B. That's the important point. It says, if there are reasonable grounds for suspecting a person is someone who may be removed under Regulation 19.3, and 19.3 had an A and a B, an A is a person who does not have or ceases to have a right to reside. So at that time, it was a very broad policy of detention. It included people who simply lacked right to reside. And of course, a person who lacks right to reside is someone who potentially is outside the free movement provisions. But in any event, it was amended shortly afterwards. And in fact, for the court's note, it was explained in the court below that this power was not actually used for detention for that purpose under Lim A. And the reference for that is Core Volume 266, page 69, and it's a subparagraph little 6 on that page. My instructing solicitor said they're slightly uncomfortable with not actually used ever, so much as don't know if it was ever used, but certainly would have been very rarely. But in any event, it was removed in July 2012, but it has nothing whatsoever to do with this case, because there's never been any doubt about the appellant's right to reside. All of the action taken against him has been on behalf because of his criminal conduct. So this has always been a case of removal on grounds of public policy. And if there's any doubt about that, I'll just give you the note. But the original deportation order made against him at Appendix 2, page 79, makes that absolutely clear. So in his case, sorry, my lord wants to go to it. Appendix 2.
There's no dispute about this.
Well, I'm not sure, my lord, to be honest, because obviously a point is made about this phantom limb A, and it's perfectly clear, though, it's completely irrelevant to the facts of this case.
Yes, I see.
But I'll just show the court the original, albeit later withdrawn deportation.
Therefore decided under 19.3b.
Exactly. That's the point.
right.
My lord.
Sixth line. Yes, I see.
So it's completely irrelevant and certainly couldn't begin to support any relief. But now, against that background, I want to turn to the alleged failure to implement, or the central alleged failure. The argument is that there's a failure to implement because at the time of the decision to detain under Regulation 24.1, there is no actual finding that the Article 27 and 28 criteria are satisfied, because it's just reasonable grounds to believe a removal will take place, which will itself satisfy those criteria. Now, it's important to be clear what those criteria require, though. And just to remind the court, Article 27.2 requires that the personal conduct of the individual concerned must represent a genuine, present, and sufficiently serious threat to fundamental interests. So what the appellant is saying is that before there can be any restriction of free movement, there must be a final finding to that effect. Sorry, a finding. I shouldn't interpolate final. There has to be an actual finding that the person represents this genuine, present, and sufficiently serious threat. Now, this is not an argument which would be restricted in its effect to detention, because the rules in Article 27 apply to any form of restriction on free movement. So this is an argument that says there can never be a restriction on free movement of an EEA national on public policy grounds until there has been a full assessment that Articles 27 and, if applicable, 28 have actually been satisfied. That's the argument that we have. But this would be evidently a severe impediment to immigration control. Because the whole point of this is that one seeks, in some circumstances, to restrict free movement precisely while those inquiries are finalised. And one can see that in a particular case, there may be very serious concerns indeed arising, for example, at the border, whether about public health or criminal conduct. There may still be a need to investigate, though. For example, there may be an issue of identity. Is this person who is in front of the immigration officer the right person in respect of whom we have these concerns? Just to give an obvious example. But on the appellant's case, the Secretary of State could impose no restriction at all on free movement, but would simply have to run the risk, admit the person, risk their absconding, risk their threat to the public. And our respectful submission is that interpretation of the directive is utterly untenable. And it may be of assistance in considering this argument just to be reminded of the approach in EU law to statutory interpretation. And just by way of example, we can see it well set out in the Sturgeon case in Authorities Bundle 10 under tab 125. And the MS page number is 3675.
Thank you. Yep.
Sorry, I'm actually not there myself yet.
Which paragraph are we looking
I'm
at?
so sorry, my lord, you're just ahead of me. Yes, paragraph 41.
Thank you.
And simply the facts don't matter at all, but this is the case where the court decided there was a right to compensation for delayed travel as well as cancelled travel. So it was creatively interpreting the regulation, if one might use that euphemism. But it says, as the court has made clear in its case law, it is necessary in interpreting a provision of community law to consider not only its wording, but also the context in which it occurs and the objectives pursued by the rules of which it is part. So that is the approach that is usually described as purposive. And in considering purpose here, it is abundantly clear that the directive's purpose is to allow member states the power to control the exercise of free movement on grounds of public policy, public health, and public security. The appellant's contentions would seriously undermine that ability in practice. So, as a matter of purposive interpretation, our submission is the directive must be read to permit such restrictions, at least for the purpose of establishing whether removal or refusal of entry will be justified.
I'm not clear at the moment. Are you saying that the decision to detain on reasonable suspicion is an EEA decision or
No, it's not. As it's defined in the regulations, it's not.
Well, I mean, you say that. I would have thought it's arguable either way. But
Well, my lord, if you conclude it is, the
no,
logical...
I'm not. I'm
But sorry.
trying to find what you're submitting.
No.
Why?
But I'll tell you why I resist that conclusion.
Well, can we just look at it? Page 673, MS 673 in volume 1.
Yes, EEA decision, and it does say a decision that concerns a person's removal. Yeah. And I accept that is not very precise language. But if my lord is correct, and this is to be read as requiring if it is a decision, then if we turn to Regulation 21, it says...
Sorry, what page is that?
I'm sorry, my lord, it's on 694 over the page onto 695. Yeah. Then the effect of this would be to simply neutralise Regulation 24.1 in its entirety. And we can see that because if one looks, for example, at subparagraph 5c, the personal conduct of the person concerned must represent a genuine, present and sufficiently serious threat. Now, one could give effect to my argument by interpreting that in a way which said, well, or at least there are reasonable grounds to believe. And from the Secretary of State's perspective, putting it bluntly, she doesn't mind which way one cuts the cake here. What she's concerned to do is ensure that she has a viable power to detain on reasonable grounds without having to actually reach a final dispositive view about whether, for example, that particular element of the test is met. Now, if this court...
Do you accept that there has to be, she's got to be satisfied that there's a genuine, present, and sufficiently serious threat at the time she decides to remove?
Oh, absolutely. That's clear beyond argument.
But before that, you say that one must interpret it as meaning she's simply got to be satisfied that there are grounds for believing that she will be able to decide.
Well, that's the effect of Regulation 24.1. Well, reasonable grounds for suspecting a person is someone who may be removed under Regulation 19.3b.
Does maybe mean maybe as in is permitted to be, or does maybe mean maybe in the future?
My lady?
You can think about that.
I think it's probably both, in the sense that obviously if they're not permitted, then this power can't apply. So if you look at this and say, this person's position is unimpeachable, it can't be anything. Principally, it's the latter.
Yes, that was what I first thought it meant. But
yes,
it then occurred to me that it could have meant the former.
Which was the phraseology in the schedule to the 71 Act, which the drafter clearly had in mind when using this phrase?
Well, I'll turn it up, my lord, if I may. It's in the same bundle, and it's under tab 1, and it's at page... it's slightly different. It's at page 570. Oh, no, it is maybe again. It's exactly the same wording.
Right.
The person is someone in respect of whom directions may be given.
I think there is authority on that, but it's in the context of that Act. I seem to recall it being interpreted as meaning is liable to be. But my memory may be playing me false.
My lord, I'm afraid I don't know that authority as I stand here. But I'm really advancing this proposition. The ability to detain without having reached a final view on whether Articles 27 and 28 are satisfied is evidently vital in a range of situations. Not detain, sorry, restrict freedom of movement. You don't need to go as far as detain. Restrict freedom of movement. The appellant says that's completely impermissible under the directive. We say, as a matter of purposive interpretation, that is wrong. I accept that essentially what Lord Carmouth is putting to me, which is there may be ways to construe this Act, this regulation in different ways. But if it's a construction that leads to that conclusion, that the Secretary of State could never detain in this case, purely on the basis of reasonable grounds, then, well, in Gaidan and Godin Mendoza terms, it would go against the grain of that. Now, what we actually said in our printed case about relief under this head was if the court was at all seduced by Mr. Saini's arguments, we'd rather come back or at least make submissions in writing about what relief would look like. Because I can see that there is scope for analysing this issue in differing ways, which is why we haven't really committed ourselves to what the consequence would be. We would rather hope to win the point at the kind of first hurdle by contending that the directive simply does not preclude this kind of approach and there is no failure of implementation.
In your case, you referred to Kadir, Lord Brown, on the construction of 16.2. This is MS 139 in the core volume. I don't know whether that helps us at all.
Thank you. Yes, we referred to this simply for the proposition that Hardiel-Singh type considerations arose under paragraph 16.2 of Schedule 2.
I just wondered whether it helps on what is meant by maybe.
I'm not sure, my lord, as the context is different, where he is talking about liability to detention, which is a term of art under paragraph 21 of the 1971 Act. I think that's right, isn't it? Yes. So I'm afraid I can't offer a firm submission on that. Can I assist further on that head of argument? Then there was just one further thing I was going to...
Okay, I mean, I'm clear about this, that you don't, I mean, what you might have said, well, in applying the discretion under the rule we're dealing with, under Rule 24, you have to treat it as implicitly incorporating, so far as relevant, the Assistance Directive. You don't say that. You say that the directive is properly incorporated in Rule 21.
Yes. Because
And, yeah.
if I was seduced by the latter option, the consequence would be the power could not be exercised without having made a decision.
Well, you would have to modify it in order to...
Well, and as I said, if this court were minded to essentially modify its application, the problem would go away. So that would be a different way of reaching the same result. And I make no bones about the fact the Secretary of State's concern is about the outcome,
But of course... But
namely that she has a viable power.
The way you put it, I understand, and I think it's helpful. Thank you.
The only other thing I was going to mention briefly, which is really for the court's note more than argument at this stage, is you heard that the appellant's claim also concerns Regulation 24.3 as well as Regulation 24.1. And I just want to make a couple of observations about that. The first is that, as we understand it, there is no challenge to any period when the appellant was actually detained under Regulation 24.3. In any relevant period where Regulation 24.3 applied, the appellant was actually on bail. And we've actually addressed in our printed case how the grounds of challenge can be transposed to a period of bail. And I don't propose to open the argument now, as Mr. Saini did not. And it's in our printed case at MS 190 to 191, 286 to 289. It's just important that the court appreciates, for the purpose of deliberation, that there isn't actually a period of detention under Regulation 24.3 at issue.
But I mean, on 24.3, you say is adequately transcribed by Regulation 21.
Well, we certainly do, and that's.
I'm not sure, is that challenge, you understand?
I think it may be, but we've made some submissions on this in our printed case.
Okay.
But I just thought it would also be helpful just to remind the court what Regulation 24.3 does. It's not actually itself a power of detention. If one could please, if we could pick up, please, the Authorities Bundle 1 again, on page 701.
Thank you. Yes.
All it is a provision that applies certain provisions of the Main Immigration Act. It says, where a decision is taken to remove a person under Regulation 19.3b, the person is to be treated as if he were a person to whom Section 3.5a of the 1971 Act applied.
And it paraphrases maybe by the word liability too.
Yes, yes. So the effect of it is simply to transfer the person into the 1971 regime. But in this case, by the time the Regulation 19.3b decision was taken, the appellant was on bail in any event. And unless I can assist further, those are the submissions for the Secretary of State.
Anything else? Thank you very much indeed. Thank you. Mr. Roberts. Thank you very much. Saini.
Well, can I hand up 4 pieces of paper? The first is following my Lord Carnwath's request yesterday for a 2-page summary of our points. And it is limited to 2 pages. Perhaps I'll wait for the court to receive those before I continue describing what they are. I've got copies from my friends as well. There's nothing new there. It's just simply a summary of the points by references to the printed case. And also it makes clear, which the court might find helpful, which particular aspects of Regulation 24 and 24.3 are challenged under each of these heads.
Thank you very much.
The second item, I hope you have there, is the explanatory memorandum, which I provided to Mr. Ward yesterday. Now, there are 2 documents. There's an explanatory document that appears in the Authorities Bundle, Volume 1, but there's an additional thing we found, which is quite important, and it will become important when I address what Mr. Ward said to my surprise yesterday, was the policy reason underlying the introduction in 2009 of this new power. Because I'll submit that what he submitted, and it's not a criticism of him, is flatly contradicted by this document. The third item is the Garcelio-Avello case, and this is in response to my Lord Toulson's request of Mr. Ward yesterday in relation to the issue of whether or not there are examples of hypotheticals being considered, and whether or not hypotheticals can amount to potential infringements or free movement rights. And the fourth and final item is a case which just deals with what the court should do when it might find that a piece of legislation is in some respects contrary to EU law, or might be applicable in a way which is not contrary to EU law. It's just a practical issue. Now, if I can begin first of all, but if the court could put those to one side, please, and take up my note concerning terms of a reference, which was the first note we submitted last week, and in particular page 11 of that note, where we set out 6 questions.
Yes.
We submit that, insofar as this case concerns issues of EU law, the court would have to find that there is an acte claire in relation to each of these 6 points. And I think it's common ground between myself and Mr. Ward that there is no clear case law concerning or disposing of the points we raise in relation to the Citizens' Directive. I'm going to come and explore those points in a bit more detail. And the court will not need reminding of the test in the Silfit case, and I'll just quote it, and indeed it actually appears in the Supreme Court practice notes, so I'll just quote it. In order to decline making a reference if one is a final court, the test is, and I quote, the point must be so obvious as to leave no scope for any reasonable doubt as to the manner in which the question raised is to be resolved. Before it comes to the conclusion that such is the case, the national court or tribunal must be convinced that the matter is equally obvious to the courts of the other member states and to the Court of Justice. Only if those conditions are satisfied may the national court or tribunal refrain from submitting the question to the Court of Justice and take upon itself the responsibility for resolving it. If the court would like to have a copy of Silfit, we've got it here, but I don't want to overburden the court, and the court will be very familiar.
We are very familiar
with that test.
Thank you.
So we say,
perhaps if you can give us, for the completeness, a copy of that paragraph and nothing else from the case in due course. Yep.
So what the court would need to be satisfied of is that in relation to our complaint concerning the Citizens' Directive, and in particular, a point I'm going to come to develop, Article 24.1 of the Charter, if it's absolutely clear to this court what the position is as a matter of EU law, which no one is submitting it can be, because my friend can't point to any clear case law in relation to that. Well, he may say he's submitting, but I think the highest...
it's clear.
Well, the highest he can put it is the Vatsuras case, and I'll come to deal with that. But he can't point to a case which deals with our submission. But we submit that if we do not succeed in this case as a matter of common law, which, as the court is aware, is our primary submission, the court must refer these questions
Yes.
to the Court of Justice. Now, with that introduction, I want to deal with a number of points which Mr. Ward made yesterday, and bearing in mind the time, I have got a speaking note. I'm not going to hand it up to the court, but everything I'm saying is in a speaking note. And if the court would find it helpful at the end of my submissions at 1 o'clock today, I can hand that
End
up.
of your submissions at 1:45. The fact that Mr. Ward finished early doesn't mean you get longer.
No, I actually was going to suggest that Mr. Ward could respond, because there's one particular, the cases I referred to, Mr. Ward needs to have a chance to respond to those. Obviously,
Yeah. Well,
that's why I was not going
anyway.
to take longer.
Yep.
Okay, first question is there actually a difference in treatment? And if I can ask the court to take our second note
Yep.
up.
Sorry,
And in-
second note.
second note.
That's, that's
Note on statutory context.
Thank
And
you.
this is quite important because in our submission, what's happened, and again, this is not a criticism of Mr. Ward, is that we have a game of smoke and mirrors here. Because Mr. Ward has on occasion suggested, but then not finally carried it through, he's on occasion suggested that there is no relevant difference of treatment between an EU national and a third country national. And he suggested yesterday in his oral submissions that in fact there is a general power to detain a third country national before a decision to remove them. But that's simply incorrect. And if I could ask you to look at our note, paragraph 14, page 5, we've set out there in some detail, and the court shouldn't have to do it itself because this is not a straightforward matter. We set out in some detail at paragraph 14 exactly what the powers are that apply to third country nationals. And that hasn't been contradicted by Mr. Ward.
Sorry, then that haven't been sufficiently clear. In fact, we do contradict this insofar as I showed the court the mechanism by which Section 10 of the 1999 Act, which is referred to in the footnote, referred back to Schedule 2, paragraph 16.2. So it's true I didn't take you to Mr. Saini's note, but lest there be any doubt about it, that is what we rely upon.
Okay, you say the position is as you described, and insofar as it's inconsistent with paragraph 14, you
Okay.
Most certainly.
deny paragraph 14's
I would agree
accuracy.
this is-
Very well. Okay.
Okay, well, my friend may say that, but this is another example of smoke and mirrors because it's not the same. It is simply not the same. And this argument was tried, one can see, before the Court of Appeal, and the court will note that having, one can see this from the skeleton arguments, in paragraph 26 of the judgment of Lord Justice Morbeck, he was having none of this. He made a conclusion that, and I quote, it's in the core volume, it's MS page number 243, which is the last tab but one. He concluded, based upon the submissions of law, that I accept that, brackets, except in the case of foreign criminals who have served a term of imprisonment.
Sorry, which paragraph?
I'm sorry, paragraph 26.
Okay.
So it's in the fourth line down. I accept that, except in the case of foreign criminals who have served a term of imprisonment of 12 months, or foreign nationals who are not EEA nationals, cannot be detained until they have been served with a notice of detention to make a deportation order against them, and to that extent their position is more favourable than that of EEA nationals. That remains the position.
So does he deal with the section with which...
Well, there was certainly, one can see in the skeleton arguments that were submitted to him, that there were submissions made in relation to the complete statutory scheme. But just focusing...
Yes, but I mean, we're not bound by what he said. I mean, as I understand the submission is that someone who has a record as long as your client's and is regarded as potentially a serious threat to public security or policy would not have got as far as your client has without having been threatened with deportation. He probably wouldn't be here at all. So the comparison is simply not a sensible one.
Well,
whether that's smoke and mirrors, I don't know, but
Well,
I mean, that's what's being said.
Well, the point is that, first of all, I don't accept as a threshold question that the conditions of entry are relevant at all. We're talking about expulsion and detention pending pending expulsion. Yeah. But can I ask you, please, if we've got paragraph 14 of my note, and
sorry, which note?
This is the note on the statutory context. I'd emphasise at paragraph 14, the 6th line, after we say this is incorrect, this point I do not believe is contradicted. The only people with extant leave to remain who can be detained under paragraph 16.2 of Schedule 2 are these individuals, these groups of people, and only those with limited leave. Therefore, perhaps I could just finish. Therefore, the person to compare my client's position to, is a person with indefinite leave to remain, who could not be removed under these powers, because the closest parallel to a person who enjoys EU law rights under the Citizens Directive and the treaties is a person with indefinite leave to remain. My client had permanent residence here. So, but what's noteworthy is that my friend can't go as far as to say that in the same situation, a person with ILR would be detained pending a decision to deport. The same point arises, my lords and my lady, in relation to the Borders Act 2007. Now, in that regard, Mr. Ward appeared to accept yesterday in his oral submissions that the detention power only arises once the statute has deemed that a person's deportation is conducive to the public good. The only decision that's awaited is while the Secretary of State decides whether one of the statutory exceptions to liability to automatic deportation applies.
Sorry, I didn't accept that.
Well,
it's quite clear that the deportation, the deeming power, as Mr. Saini describes it, only arises in respect to someone who's a foreign criminal. It has to be established both that they're a foreign criminal and then that none of the statutory defences, such as human rights or refugee convention, apply.
okay, well,
I am sorry to pop up. I hope it's not intrusive, but
we both set it out in some detail.
okay, so in our note, just again to deal with it, to move things along, in our note at paragraph 6 to 8, we deal with this, the same note on the statutory context. There is no parallel here. And the reason I call this smoke and mirrors is that Mr. Ward cannot show that in an analogous situation, the same power exists. And what he also cannot deal with, and he had no answer to this, which is until 2009, the statutory comparator that was being used by the Secretary of State was a person who had been deported or was going to be deported after a decision under the 1971 Act. That was clearly the statutory comparator, and it changed. Now, I'm going to come and look at and ask the court to look at what the explanatory memorandum said in 2009, because it contradicts what Mr. Ward said, and it's highly unsatisfactory that we're having articulated the policy for the first time extracted by this court by questions yesterday. But putting that point to one side for the moment, the only way that Mr. Ward can succeed in his arguments is not by showing that when it comes to removal, there was a parity of treatment. There clearly isn't a parity of treatment. That's absolutely clear. The only way he can succeed is by persuading this court to turn discrimination law on its head and to adopt a net accounting approach, by which I mean, and he doesn't in any way withdraw from this position. He says you've got to look at all of the rights when I get in as an EU national, and you can do a netting off of those positive rights against the detriments to which I am subject when I may be deported. And we say not only is that contrary to common sense, but it's also expressly contrary to case law of the European Union, which we cited in our case, but in particular the Roma case, R-O-M-E-R, which is the case about discriminatory treatment of civil partners when it comes to pensions. Mr. Ward tried to dismiss all of those arguments by saying, well, there's some special rule that applies in equal pay. Roma is not an equal pay case. It's a simple case of discrimination based on sexual orientation. And there the court said expressly one cannot just compare, one needs to compare the position of same-sex partners and those in civil partnerships when it comes to pension rights. It's not legitimate to do a complete total comparison across the board of all nets and benefits granted by the German state to married couples and others. So Mr. Ward is taking you, with respect, down a very dangerous road of accepting or inviting the court to accept the net accounting approach.
Yeah.
And it's not an answer for Mr. Ward to say, yes, but Mr. Nouazli would not still be here if he were not a beneficiary of the Citizens Directive. This argument is another facet of the Secretary of State's net accounting approach. Let me give you an example. Suppose women are the beneficiaries of a regime of positive discrimination to reach a certain position in employment. Suppose that they have lesser pension rights. It's not an answer to say to those women, you'd never have got the job, you wouldn't have been here if you weren't a woman, so count yourself lucky, we can discriminate against you in respect of these less beneficial pension rights. It's never been acceptable.
That's a very strange example because, of course, positive discrimination is not acceptable either unless it's specific statutory.
Absolutely. But if the court's going to decide what I say is a novel and striking proposition, which in a sense is irrational, that has to be referred. It's one of our questions, actually.
We got that point. Yeah.
Yes.
Yeah.
Now, so we say that there is a difference in treatment because none of Mr. Ward's points address this basic issue, which was accepted in the Court of Appeal, that had Mr. Nouazli not been someone covered by the Citizens Directive, he would not have been detained from April to June 2012. Now, this is where one needs to look at the issue of what was the policy reason. Because it goes to the question of proportionality and discrimination. What was the policy reason that motivated the Secretary of State? Now, the court will be familiar with the very, very strict EU law, case law, about explanations required and evidence required if one is to advance a justification. And we've quoted certain of that case law in our written case. But if you look at the explanatory memorandum that accompanied the 2009 regulations, this is the regulation that for the first time, as the court's aware, introduced this power to detain. If I could draw the court's attention to the second page under the heading Policy Background. This is where we see a policy. And if I'd ask the court to look at 7.4, please. Despite the foregoing provision, there is currently no provision for an individual to be arrested and detained in order to establish if he or she does not have or has ceased to have a right to reside. There's nothing in this which deals with this new power to detain people pending a decision as to whether or not to deport them. This is where one would have expected it, and it's highly unsatisfactory for the Secretary of State to orally state for the first time in this court what the policy was that led to the introduction of the 2009 power. One asks, this court may well ask, what was it between 1973 and 2009 which persuaded the Secretary of State that there was a fundamental problem affecting immigration control from the absence of a power to detain, pending a decision to deport? There is nothing there. It's just simply not acceptable to make it up as you go along on your feet, which is what's happened here. So we submit that, both as regards discrimination and proportionality, the Secretary of State bears a very heavy burden, the burden being heavy because we have, certainly as a matter of EU law, an interference with liberty rights and free movement rights, which require strict justification and require the Secretary of State to put evidence before the court, not assertion, heard for the first time, evidence before the court about what was it about the situation pertaining in 2009 as regards EA nationals, which made the position unsatisfactory. But there's nothing there.
I just want to say,
Okay. And in relation to the evidence needed and the level of justification, it's paragraphs 80 and 81 of our printed case and the well-known Peterson case, which says that the court should be able to identify why a particular measure was considered appropriate and necessary, but there's nothing here. Now, I want to address next another issue for reference, which is Article 21.1 of the Charter. And here we're puzzled by Mr. Ward's submissions, because the logical consequence of his submissions is that Article 21.1 is a waste of time. Now, if I ask the court please to turn up in the first volume of authorities,
Yep.
if I can find my own copy. Volume 1, tab 15.
Thank you. Yep. Page.
We can go first of all, please, to page MS 742
Yep.
and 52.2.
Yep.
Sorry, and 52.1 first of all.
Yep.
Now, this is a jurisdictional requirement. It says, if the effect of 52.1 is that once a situation falls within the scope of EU law, the application of Article 21.1 is triggered. And if one can keep a finger here and also look at the explanations to the Charter, which are at 750.
Yeah.
If you'd please look, and I don't think the court's been specifically shown this. If you look at the second paragraph on the bottom.
Well, there's no contradiction.
Yeah, and absolutely. So it's basically the fourth line in that fifth line, which begins. In contrast, the provision in Article 21.1 does not create any power to enact anti-discrimination laws in those areas of member state or private action, nor does it lay down a sweeping ban on discrimination in such wide range. Instead, it only addresses discrimination by institutions and bodies of the Union themselves when exercising powers conferred on the treaty, and by member states only when they're implementing Union law. So the gateway to the application of this Charter, the entirety of the Charter, is an implementation of Union law, and it's common ground that what's going on here is an implementation of Union law. And if one then goes back to the previous tab, to Article 21.1 and 21.2, 21.2 deals with nationality discrimination. And it basically covers essentially the same ground as Article 18 of the TFEU. Article 21.1, however, is not subject to that limitation. Pursuant to Article 52.1 of the Charter, which I've just shown you, Article 21.1 binds member states when they implement Union law. See the explanations and also the Franson case, Volume 1, tab 134. And as I've said, it's common ground that in Regulation 24, the UK is implementing EU law. As soon as the appellant situation falls within EU law, the Article 21.1 guarantees start to apply. So what we have here, and my friend hasn't dissented from this, if 21.1 applies, he says it doesn't apply, which is an issue for reference, but if 21.1 applies, we have a clear case of discrimination against beneficiaries of the Citizens Directive, and that being a particular status requires justification. Now, as I explained, 52.1 creates a jurisdictional requirement. Once a situation falls within the scope of EU law, Article 21.1 is triggered. The error in Mr. Ward's approach is that he appears to be suggesting, and I think this is the way of understanding his submission, that there's an additional condition that needs to be satisfied for Article 21.1, namely that the situation of a person can only be compared with the situation of another person on some independent ground, which is also found to fall within EU law. So I think he is saying that you can never use Article 21.1 unless the person who's getting the beneficial treatment is effectively, in our case, a British national or another national of a member state. So 21.1 essentially does the same work of 21.2. But in support of his position, the highest that he can put it is that, well, if 21.1 has the meaning that we seek to put on it, the Vatsaurus case would have been decided differently. But as the court observed yesterday, in Vatsaurus, no one raised either the general principle of equality or Article 21.1 when one looks at what the referring court was asking. So one can hardly say that it's act clear what the scope is of Article 21.1. And you will also have noted that in Vatsaurus we have about 4 lines from a section, a chamber of the Court of Justice, not much reasoning, and they're strictly answering just the questions that's been referred. Now, as we understand Mr. Ward's submissions, his submissions on comparators, according to his case, because Article 21.1 has no application, it would be legitimate to do the following. It would be legitimate for the UK government to decide that a particular class of third country nationals, let's say women, were never going to be detained pending deportation. Yet EU nationals could be detained pending deportation. And he would say, well, that's not nationality discrimination, and it's perfectly lawful for a member state to give some preferential treatment to third country nationals, even if I define them by reference to sex, because that doesn't fall within Article 21.1. So the real issue is, what is the scope of Article 21.1? There is no case deciding that issue, and that's a matter prime for a reference. Now, I believe that Mr. Ward accepts that there's no explicit authority supporting his submissions on 21.1. He points to 2 things. First, the explanations to the Charter, which I've shown you, which don't help him, they actually hinder him, because they show as soon as you have an implementation of union law, the entirety of the Charter applies, including 21.1. And secondly, he cited in his printed case the case called Camberage, which we've dealt with in our supplementary note on the authorities, which is in no view authority for the proposition he advances. But let's just step back for the moment again. This court cannot give the final view as to the scope of 21.1, and one of the questions we've identified, if one got to that, concerns the scope of Article 21.1. Mr. Ward also has no answer to those cases on the general principle of equality. So we've cited many cases where the court has decided to apply the freestanding principle of equality, irrespective of any directive and irrespective of the Charter. No answer to those cases. I want to address now the question which my Lord Torson raised yesterday, which is the question of hypotheticals, and that's raised in one of the cases I handed up, the Garcia-Avello case. And the context in which this arose is that the court will recall that in response to Mr. Ward's position in his written case that there was no complaint by the French wife or former wife of Mr. Nouazli, and therefore Mr. Nouazli essentially couldn't take the point that there was an interference with free movement rights. Mr. Ward said it's entirely hypothetical. In response, we answered with the Surinder Singh case. What Mr. Ward didn't take you to yesterday when he showed you the Surinder Singh case is the passage that we had cited in our supplementary note, where the court said that the reason that there was a violation of EU law in the Surinder Singh case was because of the pure hypothetical, which is when Mrs. Singh left Germany, if she thought her husband might not be able to remain, so when Mrs. Singh left the UK to go to Germany, if she thought that a future divorce would defeat the rights of her then divorced husband to remain in the UK, that would be an interference with free movement rights. And my Lord Torson asked Mr. Ward, well, are there any cases where these hypotheticals are considered? And the Garcia-Avello case, which the court may recall because it was cited below, but for a different purpose, is an example of that. Now, in that case, the issue was a Belgian government, wholly internal rule, emphasise a wholly internal rule of the Belgian government, which didn't allow individuals to have two surnames, because under Belgian domestic law it was considered that causes confusion. And in that case, the relevant person was a Spanish father residing in Belgium, and he wanted, in accordance with Spanish tradition, to give his children, who remained in Belgium at all material times, two surnames. No evidence of detriment. But the court held the fact that, hypothetically, in the future, there might be some detriment to the children when they went to Spain, is enough.
What's the reference there?
That's
Handed,
36 in the...
it's been handed to us.
Right, sorry.
Okay. Mr. Dubinsky rightly points out to me it's a detriment to the father because he might have been deterred from moving, which is, again, makes the hypothetical point. Paragraph 36 begins, as the Advocate General has
But it's
pointed
an
out.
effect on him. It may be in the future, but it's effect on him. And I think the point being made against you was that it isn't an effect on your client, which you are alleging. He still had cause for complaint because it affected his freedom of movement. That's the distinction, it might be said.
Well, in the Surinder Singh case, not just an effect on it, it's an effect on him and his wife.
I'm talking about Avello.
Yes.
I haven't read it, I may be wrong, but that's...
Well, I suppose I was putting it before the court to answer a different point, which is a hypothetical relevant?
Well,
And it clearly is relevant. If I can address a different point now, which is the question of the common law principle of equality. And Mr. Ward's point appears to be that because there are two different legal orders, one for beneficiaries of the Citizens Directive and the other for pure third country nationals, either the two groups are incapable of comparison, or if they can be compared, that furnishes an objective justification. Now, this is an important submission because if it's right, it would have been a complete answer in the Belmarsh case. Because British citizens are covered by an entirely distinct legal order from foreign nationals, British citizens have a right of abode, they cannot be expelled. But the point in the Belmarsh case was that the distinction in treatment between the groups concerned their liberty, and the distinction based on liberty was irrational because of the lack of objective justification. Now, one needs to focus on this point. Is this an immigration case or a detention case?
yes.
And the way that Lord Bingham approached the issue was to ask, what are the essential characteristics of the two groups of people that one might detain, bearing in mind that one can't detain in this context British nationals? And he said it was because they all posed the same security risks. And that was the right comparison. Now, applying that reasoning here, one asks, what is the difference between a pure third country national and an EEA national when it comes to security risks? By that I mean the risk of absconding or committing further offences. There's no difference. So why is it that one group, the EEA nationals, get locked up while the Secretary of State makes her mind up, and the other group remains at liberty? They both, as regards security, are in identical positions. There's nothing inherent in the quality of an EEA national that makes him or her more likely to abscond or commit offences. That's why the reasoning in the Belmarsh case, we says, applies in this particular case. Because this is really about detention based upon security risks. And there's no difference between the two positions of EA nationals and third country nationals. And I think Lord Toulson may have made a provisional observation yesterday that the Belmarsh case may be limited to saying that you cannot discriminate on the deprivation of liberty provided that the detention of the alien is not for expulsion purposes. But that's contrary to a long line of authority. It's set out in the Belmarsh case, and particularly the seminal case of Khawaja, where, as regards liberty, both Lord Scarman and Lord Bridge emphasised that every person within the jurisdiction enjoys equal protection of the law, and there's no distinction between British citizens and nationals when it comes to the right to liberty. But if one steps back, there is no satisfactory answer to this question, which the Secretary of State has ducked, which is, when it comes to locking people up, what's the difference between the two? The most he has is an argument that generally you get better rights overall as an EU national, but that doesn't meet the point. Doesn't meet the point. The next point I want to rely upon is the question of disapplication versus quashing. Now, Mr. Ward, in his oral submissions, appear to be relying upon the BB case, in particular, Lady Hell's conclusion at paragraph 60, for the proposition that unless a provision is incapable of lawful application, it should not be quashed, but should be disapplied in the individual case. But BB doesn't relate to EU law, it relates to convention law. We say that in this case, and we make no bones about this, we have a direct attack on the legislation in all circumstances. Because our primary submission is there is a difference in treatment, and irrespective of the facts of any case, there is no objective justification that has been put forward for locking up EU nationals pending a deportation decision and not locking up those who are to be deported on grounds because their remaining in the UK is no longer conducive to public good. There's no distinction between the two. Therefore, we have a wholesale attack on the legislation. Okay. It can never lawfully apply. Therefore, this is not dual-purpose legislation, which on some occasions can apply lawfully and other occasions can't. In this case, the impugned legislation can only apply to EA nationals and their family members. It always applies in a situation covered by EU law. It purports to implement EU law. And then the rationale for case-by-case disapplication doesn't apply here.
Can I be clear? I understand your point on 24.1. I don't at the moment understand your attack on 24.3.
I'm going to come back to that dealing within the context of time limits, which is, it's only essentially a time limits point, 24.3.
Yes.
So just to underline this point, we have a wholesale attack on this legislation in all circumstances, no grounds of disapplication. Now,
I understand that point in relation to your discrimination argument. I don't understand it so much in relation to the proportionality argument.
Perhaps I need to explain that. It's because the government has not explained why, up to 2009, in order to meet whatever security needs were posed, it was sufficient to have in place a power in the 1971 Act to detain only after deportation decisions. So in 2009, the government should have, should before this court or below, the government should have produced some evidence to explain that the power that existed until 2009 wasn't sufficient, that there was something that happened. It's common ground that the legal landscape in terms of the protection of the rights of EU nationals against expulsion never changed. It's been like that at least since 1973, as far as the UK is concerned. It's always been very difficult to deport an EU national, and the grounds have always been one of the interests affecting, one of the matters affecting the fundamental interests of society. Very high standard. Nothing has ever changed there. And in 2009, we have unexplained a very severe measure introduced. I say it's severe because it leads to a deprivation of liberty, therefore it's by definition severe. The government, applying the London test, has to show that this measure goes no further than is necessary to meet a legitimate objective. Where's the evidence? So that's why I say that in every case, this is a disproportionate power, because prior to 2009, it was never needed. And I do make this point, I made it more than once, but it's a puzzle. It has been introduced without anyone giving any thought to why it was introduced, and no justification being offered for its introduction. Therefore, in response to my Lady Hell's point, the point about the lack of justification goes not only to discrimination, but also proportionality. Why was it strictly necessary? And we do not accept that a vague assertion of policy, which we heard for the first time yesterday, is an answer. The policy may be to detain EU nationals prior to deportation decisions, but why? That's not an answer. What's the reason for the policy? There's nothing there. This court shouldn't be guessing, and in essence, it's illegitimate for the court to be guessing. It's for the Secretary of State to explain why. Now, the reason I have produced the Commission and France case, which is the last one of the authorities, is that if the court considers that there are parts of the legislation that could remain, and in certain circumstances, the legislation in application might be unlawful, that case, we say, is authority for the proposition that it's inconsistent with the principle of legal certainty to leave legislation on the statute book,
Right.
which may apply in certain circumstances to those exercising EU law rights and be inconsistent with EU law. Again, it's in a sense common sense. You can't leave something which might be. It's paragraph 41. Okay, the case itself the case itself concerns a French maritime law, which required that a certain proportion of the crew of ships should be French nationals. That obviously discriminated against nationals of other member states, contrary to EU law. And the Commission brought enforcement proceedings. And the European Court of Justice held that it was no answer to the breach of EU law, that those provisions were directly effective, and that in practice, when it came to specific applications, they would not be applied to the detriment of EU nationals. In other words, sometimes when an EU national complained, they wouldn't be applied. If other nationals complained, they could be properly applied. And the court, not surprisingly, said that that creates such a level of uncertainty that the right course is not to leave the measure in place at all. And in a sense, the position here is a fortiori because we have a measure which only applies to EU nationals. And it's implementing an EU law measure. I'd also, I know the court will have this in mind, but in the Belmarsh case, the Attorney General offered an undertaking to the court that he would not apply, as a matter of concession, the relevant legislation to certain persons. But as Lord Bingham stated at paragraph 33, it's not acceptable that the interpretation and application of a statutory provision which bears upon the liberty of the individual should be governed by implication, concession, and undertaking. Therefore, if we're right, we say the right thing for this court to do is to quash the legislation. If the Secretary of State wants to come up with something else, no doubt she can do so. I want to deal lastly with the question of time limits and explain what the position is. Now, I believe it's common ground between the parties, but Mr. Ward will tell me if I'm wrong, that in construing EU legislation concerning fundamental human rights, and in particular in applying the Charter, the EU courts, or the domestic courts interpreting EU law, can go further than the Strasbourg Court. And were any authority needed for that, and the court doesn't need any more bundles, it's very succinctly summarised in the judgment last week of the Court of Appeal in the data retention case, where they referred some questions to the European Court concerning the digital rights case. So it's absolutely clear that and I'm happy to say that Mr. Ward is nodding for once, it's absolutely clear that the European Court and this court, in interpreting the Charter, can go further than the Strasbourg.
Yeah, we have that.
We submit that, without prejudice to our submissions in relation to what the Strasbourg Court has so far said in relation to Mathloom and similar cases, when it comes to the principle of free movement and the principle of liberty, which are both rights protected under the EU Charter, it's not for this court, but it's ultimately for the Court of Justice of the European Union to say whether, as a minimum, there should be mandatory time limits. Now, if we end up in the Court of Justice, which we say we should end up, and because there is no act clear in relation to this, the submission is going to be an obvious one, which is that those with the least rights within the Union, third country nationals being deported out of it, have the benefit of a mandatory time limit in the Returns Directive. It cannot be right, in accordance with the principle of legal certainty, that those in the position of beneficiaries under the Citizens Directive should have lesser rights. Now, there must have been a good reason why the EU legislature decided that even if something like Hard-Yul-Singh principles applied, there had to be a mandatory time limit to detention. But when one looks at the Citizens Directive, in particular Article 27, which its common ground contains a condition of proportionality, and it's common ground that all EU measures, or all implementing measures in domestic law, implementing EU law, must satisfy the test of legal certainty, we say that it's for the ECJ rather than this court to say whether or not the absence of mandatory time limits vitiates this power to detain. That applies both to Article 24.1 and 24.3.
Thank you.
So that's where it arises.
That's your answer to Lord Conworth. Yep.
Indeed.
Thank you. Yep.
And I do want to emphasise that we are not saying that this court should say that the Hard-Yul-Singh principles should be replaced. They are very useful principles, and they are the principles that are regularly used to release people from detention, sadly, after they've been detained for a period of time which the court decides is unlawful. We're saying that they should be complemented with a mandatory time limit. And therefore, we wouldn't want this court to in any way seek to weaken the Hard-Yul-Singh principles. Just in relation to the two final points I want to deal with in the last 5 minutes. One is transposition. If I could ask the court to look at what we've called the law on our side, the Lord Carnwath note, which was the first note that we handed up this morning.
What, the table?
The summary, yes.
Issues raised in different
Absolutely.
courts. Yep, we have that, thank you.
Just so that the court has our position clear in relation to the transposition clause, we've summarised it at paragraph 8.
Thank you. Yep.
And then finally, my Lord Clark raised an issue about what are the damages going to be in this case.
Yep.
And we submit that if the legislation is quashed, our client was unlawfully detained. There was never any power.
We understand that.
So by contrast to the Lumber case, where it was simply a question of the application of an unlawful policy when the lawful policy would have justified detention. So there was no power to detain. And the bracket for damages in our case, based upon precedents, will be between £14,000 and £25,000 for the period of detention.
Okay, thank you.
Sorry?
Between £14,000 and £25,000.
14 and 25,000 for
Yes.
2 months.
For the total periods of detention, when we say
2 months.
9 months.
9 weeks, 9 weeks.
I'm sorry, 9 weeks.
Yeah, 2 months.
9 weeks.
2 months, as Lord Conworth says.
Sorry, where do you get that 25,000?
Well, again, I'm relying upon what Mr. Binsky told me. I'm informed that the legal authority is the case of Thompson and Sue.
Saying that there's
Okay.
no clear authority.
All right.
Sue spelled how?
Yeah.
That's why we're deducing a wide range.
Okay. And this is again a very wide bracket between 14 and 25.
There have been lots of cases decided under the Hard-Yul-Singh principles where people have been detained for a month
Okay.
or so.
Well, basically, the principle is that the sum is relatively high for the first 24 hours and then tapers after that. again, we're in a sense shooting in the dark here. I'm doing my best to give you a figure.
Thompson and Sue, how's Sue spelled?
HSU.
Thank you so much.
And there's no flat rate.
Okay.
So there's variation.
All right.
The rate at which damage is
Again, there being no flat rate, and there's a considerable variation in the authorities at the rate at which the damages taper off.
Mr. Saney, were there any other points you were about to make?
No, my lord.
No. Can I take you back and ask you one matter, please? You've said and reminded us that there's no evidence to explain the change in the regime in 2009. I've been looking at the original grounds for review, and this doesn't appear to have been any part of your complaint then.
Well,
I've been looking also at the schedule prepared by the respondent. This appears, if I've got it right, not to have featured in the argument either at the Administrative Court or in the Court of Appeal.
well,
Is that correct?
well. What happened, my lord, was that we made an equality argument. The Secretary of State clearly made a policy decision to meet the equality argument by saying that we didn't have the right comparator. So what the Secretary of State could have done, which is commonly done, is have made 2 points. One is, I accept there's a comparator, but there are these objective differences, and here is my reason. This is my reasoning for introducing this measure. But they took a policy decision not to advance any explanation.
The Secretary of State might have done all sorts of things, but I don't think you've answered my question. Am I right in understanding that the complaint, that this is disproportionate because it hadn't been necessary until 2009, what made it necessary in 2009, was not raised at first instance or in the Court of Appeal? Am I correct in my understanding
Well,
of that?
the issue of whether or not it was discriminatory definitely was raised.
Can-
I'm answering my lord's question.
Well, I
because
hope
the
you're going
answer, and the way that the Secretary of State dealt with the discrimination argument was not to put forward any evidence, but the evidence would have been the same. So, are we left in this? We're left with an unsatisfactory position where, Lord, the issues raised in this appeal clearly do raise. No one has disputed this. Mr. Ward hasn't said he wants some time to put in some evidence, and this he's taken by surprise by this point. We've raised it fairly and squarely in the issues which he's agreed. We raised it fairly and squarely in our written case. It's never been said by Mr. Ward that I want to put in some evidence, and Mr. Ward and his team are able, experienced advocates. If they had any evidence, I'm absolutely sure he would have submitted it. But what's happened here is that the Secretary of State introduced this power in 2009 without giving any thought to it. There's no material indicating any thought having been given or any disclosure of the reason for the introduction of this intrusive power. So it's been on the table, my lord. And if Mr. Ward wants to say, well, I need an adjournment, put some evidence in, he could have said that. He's never said that. He's preferred to advance his case on a different basis, which is that there aren't like comparators, therefore I don't have to justify by way of evidence. Well, those are my submissions.
Thank you very much indeed. You certainly have the right to apply on the two cases.
My Lord, that's all I was going to do, other than just to put a caveat on what was said to be my consent to the proposition that the European Court can go further. I don't disagree at a level of generality, but in the case of the Charter, the position is slightly different, which is Article 52.3 says, insofar as this Charter contains rights which correspond to rights guaranteed by the Convention, the meaning and scope of those rights shall be the same. And Article 5.1f corresponds to Article 6, part of Article 6 of the Charter, and the explanations confirm it should be given the same meaning. So I was a bit over-enthusiastic with my nodding, for which I apologise. So as to the two cases, though, neither of them help in the slightest. The French infraction case, which was just handed up, is one of a series of cases where the European Court has found a failure to implement a directive where the member state has statutory provisions that say one thing and an administrative practice that says another.
Yep.
So the statute said they all had to be French nationals, but the French government explained, well, that's not how we apply it. And it's hardly surprising the European Court is not very keen on that. But that's a totally different problem. Garcia Avello does nothing to fortify the arguments over Surinder Singh and so forth, because what the Court of Justice is saying is this inability a discrepancy in surnames is liable to cause serious inconvenience for those concerned at professional and private levels. So it's talking about a real practical problem, rather than a divorced, an ex-wife of 10 years ago suffering some hypothetical detriment to her long since exercised free movement rights. Unless I can assist further, that's all I was proposing to say.
Well, can I just mention one point? I'm sorry to interrupt my friend, which is in relation to the Charter. I thought my friend had accepted that the Charter could go further, because you'll recall that 52.3 says that the provision which says that the Convention rights correspond with the Charter rights adds the following important sentence at the end. This provision shall not prevent union law from providing more extensive protection.
I hoped I'd made clear I concede that proposition.
Right, well, it's nice to end on a position of agreement. Thank you both very much for your oral submissions. Thank you also to all those involved in the preparation of the written cases. We will consider this appeal and give you our decision in due course. Thank you all very much indeed. The court is now adjourned.